The board meeting and the full board, the full board hearing this morning. The first order of business is to call the roll.
Good morning. Priya Mathur.
Good morning.
Rob Fechner.
Good morning.
Margaret Brown.
Good morning.
John Chung.
Excused, I guess.
Richard Costigan. Here. Richard Gillihan.
He's excused.
Okay. Dana Hollinger.
Here.
Henry Jones.
Here.
David Miller.
Here.
Ramon Rubicava.
Here.
Bill Slayton. Here. Teresa Taylor.
Here.
And Lynn Peck-Win for Betty Yee.
Yes, please note for the record that Mr. Gillihan is not here. He's recused himself from this item. We do have a quorum. The next order of business is approval of the August 14th, 2018 Board of Administration timed agenda.
Move approval.
Moved by, thank you, moved by Mr. Jones, seconded by Ms. Hollinger. Any discussion? All those in favor say aye.
Aye.
All opposed? Motion passes. That brings us to agenda item 3. We open the record for the full board hearing in the consolidated appeals of members Robert T. Wolf and Kenneth L. Hale, CalPERS case numbers 2016-0211 and 2016-0212. Let us first take roll call, please. We'll take. We've taken the roll, but maybe we should. I think we've just taken it. So, do we need to take it again? I see our general counsel shaking his head. So I think we are in good shape there. Thank you. The proposed decision in this case was originally considered by the board at the May 2018 board meeting. At that meeting, the board rejected the proposed decision and scheduled this matter for a full board hearing on the question of whether the compensation at issue should be included in the members' final compensation calculation. I note for the record that all parties have received notice of this full board hearing, along with copies of the Statement of Policy and Procedures for full board hearings before the board. In addition, all parties have been informed in writing that oral argument will be limited to 10 minutes for each position, and rebuttal will be limited to 3 minutes for each position. Would council please take a moment to introduce themselves, starting with staff counsel and then the members council.
Good morning. Marguerite Seaborn, CalPERS, the legal team.
Good morning.
Good morning. John Shipley on behalf of CalPERS.
Good morning.
Good morning. Lynna Balchunas Cockrell on behalf of respondents Kenneth Hale and Robert Wolf.
Good morning. You need to turn on your microphone. There we go. It's on now.
Okay.
Yeah.
Gary Messing, also on behalf of the respondents.
Good morning.
Thank you.
Thank you. So let the record reflect also that Chirag Shah, the board's independent counsel on full board hearings and proposed decisions from the Office of Administrative Hearings, will be here to advise the board on procedural and substantive issues and to answer questions that board members may have today. Mr. Shah will also provide a brief summary of the case before we begin oral arguments. As stated previously, each position will have 10 minutes for oral argument. Mr. Shipley will first have 10 minutes to present staff's argument. And after that, Ms. Balchunas Cockrell will have 10 minutes to present argument on behalf of the 2 members. Neither side is compelled to use the full 10 minutes. However, if a party concludes argument in less than the time allotted, it will not be permitted to carry that time to any other portion of the proceeding. After both sides have presented oral arguments, each side will be provided 3 minutes for rebuttal arguments in the same order as the original presentation. First, Mr. Shipley for staff, then Ms. Balchunas Cockrell for the members. Here too, you may, but do not have to, use the entire time allotted for rebuttal. But if you decide to use less time, you will not have another opportunity to use any time remaining in your rebuttal. There is a timer in front of you which will be set for 10 minutes. It should be right in front of me, actually. You'll see it right here. For the initial argument and 3 minutes for rebuttals. The timer will begin when you start to speak. Please pay close attention to the timer as you make your presentations in order to avoid going over your allotted time. When the timer's light turns red, your time will have expired. After all sides' arguments and rebuttals are concluded, the board may ask questions of any of the parties to this proceeding, as well as our independent counsel. The alternatives available to the board are set forth at agenda item 3 of the board meeting materials. Any questions so far? Do the parties understand the procedure?
Yes, ma'am.
Thank you. Now then, Mr. Shah, please provide a brief summary of the case.
Thank you. Good morning, Madam President, members of the board. As you said, my name is Chirag Shah, and I'm the board's independent counsel on full board hearings. My summary here this morning, as usual, will be very, very brief. I will let each counsel educate the board on the details and the merits of their respective positions. This consolidated hearing is for two separate but substantially similar disputes over the calculation of final compensation under Section 20636 of the Public Employees Retirement Law, or PERL. Because of the similarities in the legal and factual disputes in the two cases, the parties agreed to consolidate the cases into one hearing. Members in this case are retired firefighters, battalion chiefs to be more precise, with the California Department of Forestry and Fire Protection, or CAL FIRE as the agency is more commonly known. At all times relevant to this appeal, both members were on full-time release for union business as permitted by the Memorandum of Understanding or Collective Bargaining Agreement between CAL FIRE and CAL FIRE Local 2881, which is the exclusive bargaining representative of professional firefighters in the state of California. During their full-time release, members received annual mandatory cash outs of holiday pay as required by the MOU between CAL FIRE and Local 2881. The specific issue before the board is whether the annual mandatory cash outs satisfy the requirements of subsections C and E of Section 20636 of the PERL and its implementing regulation at California Code of Regulations Title II, Section 571A5. CAL FIRE, which has not entered an appearance in this matter, did not report the mandatory cash outs as compensation earnable, but requested that they be considered by CalPERS at the urging of the union. The parties appearing before you today agree that the material facts are not in dispute, as outlined by the administrative law judge in the proposed decision. The details of the case, the history of the litigation, and the merits of each party's position are presented in the written arguments in the administrative record before the board at Agenda Item 3. Madam President, board members, that concludes my brief summary of the case. Thank you.
Thank you very much, Mr. Shah. Let us now turn to preliminary evidentiary issues. As all parties are aware, we are not here to relitigate factual issues or resubmit evidence into the administrative record. However, in rare circumstances, the interest of achieving a just result may require consideration of newly discovered relevant documentary evidence, which could not, with reasonable diligence, have been discovered and produced at the hearing before the administrative law judge, and which therefore is not part of the administrative record. Under no circumstance may the board accept new witness testimony or any kind of examination or cross-examination of anyone, including board members, in today's proceedings. Under the board's procedure, requests to introduce newly discovered documentary evidence must have been submitted in writing to the board secretary no later than the due date for written arguments, which in this case was August 3rd, 2018. In order to avoid interruptions during each party's respective time today, please let us know now if either party has any relevant, newly discovered evidence which could not have been discovered and produced at the hearing that it seeks to be admitted into the administrative record today, as to which a timely written request was submitted to the board.
No, Madam President.
Thank you.
No, Madam President.
Thank you. Mr. Shipley, do you have a, oh, sorry. Since seeing that there are no requests to submit newly, sorry, I'm reading a bit of a script. Seeing that there are no requests to submit newly discovered evidence, let us begin oral arguments at this time. Mr. Shipley, please present staff's argument. Please start the clock for 10 minutes when Mr. Shipley begins the argument.
Good morning, Madam President and board members. We're here today because respondents receive benefits, vacation leave and holiday cash outs that none of CAL FIRE's other 6,000 plus firefighters received. These cash outs were never reported to CalPERS as pensionable income, and neither CAL FIRE nor respondents ever paid contributions on the cash outs. Through this appeal, respondents are seeking a second benefit that no other CAL FIRE firefighter receives. They are seeking to boost their pension benefits by including the holiday cash outs as compensation earnable. The PERL says this is not allowed. Why not? First, an item of special compensation must meet the specific definition provided for in the PERL to be pensionable. Second, the PERL requires special compensation be available to all members of a group or class to ensure that everyone has the same opportunities and are treated equally. As the California Court of Appeals said in the Prentice case, the central role of the limitations on compensation earnable is to prevent agencies from artificially increasing a preferred employee's retirement benefits by providing the employee with compensation increases which are not available to other similarly situated employees. So let's look at the facts here. Both respondents were firefighters with CAL FIRE, and their compensation and benefits were entirely dependent on their bargaining unit's MOU and their firefighter rank. They were elected as union officers and placed on full-time leave for the terms of the firefighter's MOU. But they remained CAL FIRE employees, and their compensation and rights, including their designation as a state safety member with CalPERS, continued to be entirely dependent on their job classification with the state, which was their rank. They both promoted to a higher rank while on leave. They both promoted from fire captain to battalion chief. Once they promoted, their job classification with the state changed to their new rank, and they received compensation and benefits equal to that of CAL FIRE's other battalion chiefs. I think that bears repeating. They were paid as if they were working as battalion chiefs, despite the fact they were on leave and never actually worked as battalion chiefs. Although they generally worked out of the union offices from 9 to 6, they received the same pay and benefits as other firefighters of the same rank, meaning their regular schedule called for them to work 45 hours a week, but they were paid as if they worked 72 hours a week. Like other firefighters, they were allotted floating holidays based on the number of state-approved holidays each year, and they received approximately 19 hours of annual leave each month, or 28 days per year, again, based on the firefighter's MOU. Respondents were the only firefighters who were able to and did cash out their vacation and holiday leave credits. Respondents did not use a single vacation or holiday credit during the entire time they were on work release, so they cashed out 40 to 41 days of leave each year. No other CAL FIRE firefighter was ever able to cash out this leave on a yearly basis. To repeat that, no other CAL FIRE firefighter was ever able to cash out this leave on a yearly basis. Beyond that, no other CAL FIRE retiree has ever been able to claim that her or his leave cash outs should increase her or his retirement benefits. So, at the general principle level, the Pearl says that the cash outs these two men received is not pensionable because the cash outs weren't available to any of their colleagues. The Pearl requires that an item of special compensation be available to all members of a group or class of employment, and respondents were the only firefighters who received the benefit of being able to cash out holiday pay. That general principle, that income is only pensionable if it is available to all on an equal basis, then drives the specific provisions that apply here. The specific item that respondents want to make pensionable is holiday pay. It is legally defined as additional compensation for employees who are normally required to work on an approved holiday because they work in positions that require scheduled staffing without regard to holidays. For an item of pay to be pensionable, it must meet this definition, meaning there's essentially two requirements. Employees must be normally required to work on an approved holiday, and they work in positions that require scheduled staffing without regard to holidays. Were respondents in positions that required scheduled staffing without regard to holidays? The answer is no. Was there even a schedule? The undisputed evidence was that there was not. Prior to respondents being on full-time release, they had a schedule that told them who was working, what each person was doing, and when they had to do it. But once they became union officers, they had nothing similar. Now, the argument respondents advance is that there was no schedule because they literally worked all the time, 24 hours a day, 7 days a week, 365 days a year. So they argue the necessary scheduled staffing is a simulated yearly calendar that showed them on duty every day of the year without a single day off. And they kept that schedule for 10 and 8 years respectively. That can't be what scheduled staffing means. Their real schedule was 9 to 6, 5 days a week. When they worked on other days, that's more accurately characterized as standby or on-call work. For example, remember what Mr. Hale said about his trip to Hawaii. A trip to attend training that he extended by 3 days to spend time with his wife in Kauai. He testified that he took some calls while he was there. Does that qualify as working? In his words, Mr. Hale described his holidays as sometimes being interrupted by calls. And remember, Mr. Hale also said that if he did receive an urgent call and wasn't available, the call would just have to wait. Based on these facts, you cannot conclude that he was normally required to work on holidays. Someone who is required to work without regard to holidays cannot have their holidays interrupted by calls. They don't get a holiday because they are working. What respondents did was standby or on-call work, which is not pensionable. And remember, respondents were getting paid as if they worked 72 hours, the last 19 hours each week treated as pensionable overtime pay. So they were compensated for working outside of their scheduled time for work. In fact, they were compensated as if they worked 10 hours a day, 7 days a week. And that pay was pensionable and used when determining their retirement benefits. What respondents are trying to do through this appeal is tack on additional pensionable income to work they already received compensation to perform, and pensionable compensation at that. The PERL does not allow this. But even if respondents had a schedule that called on them to work every day of the year, the question is whether their positions required such staffing, i.e., staffing without regard to holidays. We all know jobs that require staffing without regard to holidays: police officers, correctional officers, hospital doctors and nurses, and yes, firefighters. There's a requirement that these positions be staffed at all time. By contrast, nothing required respondents' union officer positions to be staffed at all times. In short, respondents failed to establish that they worked in positions that required scheduled staffing without regard to holidays. Their appeal fails on that basis alone. But in addition, respondents also failed to establish the second prong of the test, that they were normally required to work on approved holidays. There is no evidence that they were. What they said is that the membership expected them to be able to answer the phone when they called, and they did so. That's admirable, but it's not the same as being required to work on holidays. As I stated a moment ago, there's a term for that. It's called standby work, and pay for standby work is not pensionable. For 6,000 plus of CAL FIRE's firefighters, the men and women who are out there right now fighting fires, they are in positions that require them to work on holidays and require scheduled staffing. However, none of these men and women are allowed to cash out the holiday credits they receive. They either use them to take time off or they wait until they retire to cash them out. And like every other CalPERS member who cashes out vacation or holiday credits when they retire, the compensation is not pensionable. Here, respondents are the only firefighters with CAL FIRE who received holiday pay cash outs, and they are insisting on being the only firefighters to have the cash outs included as part of their pensionable compensation. Think about that again. The other firefighters are in positions that actually require them to work on holidays. And unlike respondents, when they're working on holidays, they don't have the option of spending time at home with their friends and family. None of CAL FIRE's other firefighters received holiday pay cash outs, and none of them have appealed to have their retirement benefits increased. The firefighters' MOU states respondents should not lose compensation while on release. However, it does not say respondents are entitled to receive compensation and retirement benefits above what everyone else gets. There are 3 independent reasons why CalPERS could not legally give respondents what they want here. They did not work in positions that required scheduled staffing without regard to holidays. They were not normally required to work on approved holidays, and they were the only members of their group or class who received the items of special compensation. The administrative law judge agreed. The administrative law judge correctly applied the facts to the law when reaching his conclusion. For these reasons, CalPERS respectfully requests that this board affirm CalPERS team determination and adopt the proposed decision following remand. Thank you.
Thank you, Mr. Shipley. Ms. Balciunas-Cockrell, it's your turn to present member's argument, and you will also have 10 minutes.
Thank you, Madam President. One of the biggest problems we have had in this case over both hearings is trying to analogize the positions of the union officers to other state employment, and I think it's pretty undisputed that we cannot. These are unique positions in state employment. The record reflects that Mr. Hale and Mr. Wolf did not have supervisors at CAL FIRE. They did not have supervisors within the state. They did not receive performance evaluations. They were not paid for the time actually worked, which is different than had they been in battalion chief positions in a ranger unit. And Mr. Hale testified that he had been working as a fire captain in the Nevada Yuba Placer unit before he was elected into his full-time union officer position. And the 72 hours that they continued to report on their time cards is a straight 72-hour schedule. It is as if he worked from day to night to day to night to day to night over 72 hours. So it is not necessarily 7 days of 10 hours a day. The battalion chiefs in the units don't get paid that way, and neither did the union officers. The difference with the battalion chiefs in the units is that outside of those straight 72 hours, they work additional time and get paid overtime for that. And while that overtime is not pensionable, it can be factored into retirement by the firefighter due to their own financial planning. The union officers did not have that option. They were paid for the straight 72 and only the straight 72 throughout their time in office. The pension law is certainly not clear that this item is not pensionable, and in fact, due to the plain language of the law, it's clear that the cash outs are pensionable. And if I may draw your attention to section 20636E1 that defines group or class of employment, it is a number of employees considered together because they share similarities in job duties, work location, collective bargaining unit, or other logical work-related grouping. Now, the ALJ, the administrative law judge, in both hearings, the original hearing and the remand hearing, focused on rank because of the salary, benefits, and promotional opportunities. None of these things are listed in subsection E1. The statute goes on to say that one employee may not be considered a group or class. So the question is not whether these cash outs were available to all 6,000 members of the bargaining unit. The question is whether the cash outs were available to all members of the group or class that could not be a single employee. Therefore, it is logical to infer that 2 employees could be considered a group or class. The other problem with the administrative law judges and with counsel's interpretation is it fails to account for other clearly, undisputably pensionable pay differentials that cut across rank or employment classification. And the ones that we had direct evidence of at the remand hearing from Mr. Hale, then current President Mike Lopez, and current state rank and file director Tim Edwards, for example, our longevity pay. If you work for the state for a certain amount of time, you get a pay differential that is expressly pensionable, undisputedly pensionable, but it doesn't matter what your rank or classification is. And some firefighters choose to be on the fire lines, not try to ascend the ranks through their whole career. They still get the same longevity pay as does a battalion chief at the top of the bargaining unit. Another one is the educational incentive. If you qualify for the educational incentive, you get it across the board. And CalPERS has recognized this in another case that just came to our attention last week that I wanted to draw your attention to, and I do have copies. It is judicially noticeable if we were in court and officially noticeable here, but it is the matter of George B. Magellanes. This was adopted by the board at the March 21st meeting of this year, and it involved a deputy law enforcement officer down south who was seeking to have pensionable a patrol and custody training pay as well as a patrol station retention bonus. And the ALJ found that the information available regarding these pay differentials was limited, but that the record did establish that the county provided the patrol station retention bonus to those deputies who were assigned to a patrol station for 36 consecutive months if the deputy was at the top step of the pay range during 12 of those months. In those cases, the deputy was entitled to a lump sum bonus. Now, during the hearing, CalPERS took the position that, similarly to this case, that the bonus was not available to all of the deputies, and therefore it could not be pensionable. In the proposed decision, the administrative law judge noted section 20636 C1 that special compensation of a member includes payment received for special skills, knowledge, abilities, work assignment, work days, or house or other work conditions. And the decision noted that there were many other positions within this law enforcement category that received pay differentials, being on patrol being one of them. And again, it didn't matter how long you had been in your position. You could have been there for a year, you could have been there for 20 years, you still got the pay differential, and therefore your rank or your employment classification was not the determining factor for whether this, this item was pensionable. Ironically, Mr. Shipley was also CalPERS' attorney in that matter and recommended to the board that this decision be adopted, where the administrative law judge did find that this patrol station retention bonus and patrol and custody training pay was pensionable, and the board adopted the decision in the March 2018 meeting. Turning over to the scheduled staffing element of the union officers here, Mr. Hale testified at the remand hearing that the purpose of his schedule when he was in the Nevada Yuba Placer unit was to ensure that the position was filled and that his colleagues knew who was on duty at what time. There was no need for a written schedule for the union officers. The position of president and state rank and file director were filled by the two gentlemen in office, and they were always on duty. And it's hard to conceptualize a job where you don't come in and sit at your desk and do your paperwork and then you're done. As we see now, fire season is year-round. The gentlemen on the fire lines don't get to take time off. They have issues all the time regarding their safety, regarding their sleeping arrangements, regarding their pay. They are not able to negotiate individually or bring their concerns individually to the state. That would just be unmanageable. The union does that for them. And these gentlemen, Mr. Hale and Mr. Wolf, gave up their careers to speak on behalf of the 6,000 men and women who are out there keeping our state as safe as it can possibly be during these horrendous conditions. And Mr. Hale testified that actually during a time of extreme emergency, a few years into his tenure as the state rank and file director, he went and requested to be placed out on the fire line because he had tremendous experience and tremendous skills and could be an asset. And that request was rejected because of his union officer position. So they gave up benefits that they would have received had they stayed in their positions as battalion chiefs in a ranger unit. And this is a very minimal request that they're making because they spent so much time over such a long period of time directly addressing the needs of the members, the needs of the state, the needs of CAL FIRE, and it's undisputed in the record that the state expected Mr. Hale and Mr. Wolf to be on duty 24 hours a day, and that CAL FIRE expected Mr. Hale and Mr. Wolf to be on duty, and that includes, for the state, the governor's office as well. And if there was an accident, if there was a major critical condition, things could not move forward without Mr. Hale and Mr. Wolf providing the appropriate union representation and response. And failure to do that, failure for Mr. Hale and Mr. Wolf to be available to be on duty at that time would prevent the response from moving forward and impair the safety of the personnel involved. So these were critical positions. This was not a cush job seeking a cush retirement for pension spiking at the end. They gave their hearts and soul to these positions, gave up their families, gave up their holidays, and are asking just for the cash outs that they were required to take. They could not bank and take months off altogether at the end, that these be pensionable. Thank you very much.
Thank you very much. Mr. Shipley, would you like to offer a rebuttal at this time?
Yes, Madam.
Okay, if you could turn on your microphone, please. Thank you. Please start the clock for 3 minutes for staff's rebuttal, and you may proceed.
First, I'd like to just briefly address, council has brought up the Magallanes decision. That case was based on the specific facts and the specific evidence of that case. What we're here today to discuss is the specific evidence and facts of this case. And I agree, viscerally, these individuals, they're on full-time leave. They just don't quite fit into what we conceive as typically a group or class. But I think if you take a step back, they actually really do. The Pearl defines group or class as a number of employees considered together because they share similarities in job duties, work location, collective bargaining, and other logical work-related groupings. Respondents are critical of CalPERS and the ALJ because there was a focus on compensation as the critical factor in determining their group or class. Respondents go as far to argue as the statute doesn't even mention compensation, so why would compensation be something that should be considered? It's true that that specific statute, that specific subsection doesn't mention compensation. But when you take a step back and look at the bigger picture, that specific subsection is contained within the definition of compensation earnable. So the whole idea is, what group or class should they be in when you're considering what their compensation earnable is? So, their job duties. Did respondents' job duties with the union in any way impact their compensation earnable? No. Their pay rate was based on their rank. Did respondents' job location in any way impact their compensation earnable? No. Their job location in no way impacted their compensation earnable. Did respondents' rank within CAL FIRE determine their pay rate? Yes, it did. Did respondents' MOU determine the special compensation they received? Yes. So when you think about what factors are relevant in determining what their group or class is for purposes of determining their compensation earnable, it's their rank and it's their MOU. The fact that they were on full-time leave, and they've argued this, different people in different ranks come into the positions, but that doesn't impact their compensation earnable at all. It's the fact that what their rank is with CAL FIRE. But that's not really the critical key here. The critical key is, do they meet the definition of holiday pay? And they don't. Their argument that they work a 24 hours, 7-day a week, 365 schedule just defies logic. A trip to Hawaii, the holidays being interrupted by calls. If respondents were truly working on holidays, if they were in positions that required scheduled staffing on holidays, like CAL FIRE's other firefighters, the testimony would have been their work was interrupted by calling friends and loved ones on holidays, not the other way around. Thank you.
Thank you, Mr. Shipley. Ms. Balciunas-Cockrell, would you like to offer a rebuttal?
Thank you, Madam President. Yes.
Please, so this clock has been started for another 3 minutes for your rebuttal.
Thank you. Mr. Shipley refers to rank and MOU being the determining factor, and it is the MOU from which the cash outs are derived. It is a mandatory cash out, and just to clarify, section 10.1.6 of the MOU actually gives employees at their option to cash out up to 4 holidays per fiscal year. In contrast, for the union officers, section 2.8.2 requires that the holidays be cashed out each year. And that was, it is easily inferred that that was with the understanding that the union officers would be on duty all the time. They would not have flexibility with being able to take the holidays and being untouchable during those holidays, such that if there was a time when the union officers left their positions and went back to a ranger unit, they would not be bringing these huge leave balances with them because they had spent so much time being unable to take vacation and holidays. And so that is where the uniqueness of their position is recognized by the state in its negotiations with Bargaining Unit 8 for the MOU. Much is made of the Hawaii trip, which was taken for business purposes, and in an attempt to try to take some vacation time afterwards, and realizing that it just simply wasn't possible because of the necessity of being on duty during that time. And as we've noticed, the demands of the fire season have increased in both time and severity as time has gone on, and that has been the case for the union officers as well. I think certainly there was a time in the past where we could say that there was an off-season and perhaps some more flexibility, but as Mr. Wolf and Mr. Hale came into office, that diminished and disappeared. So they have been catering to the needs of our statewide fire safety personnel and have done so without regard to their own schedule for nearly a decade. And that is where the cash outs are reflected as part of their compensation and their special compensation. And they fit into every other part of section 20636E1 with the duties, the uniqueness of the duties, the uniqueness of the work location, and all of the different logical work-related groupings that apply to them and only to them. and that is why they should be considered as a group or class of 2. There is nothing in the PERL that prevents them from being considered a group or class of 2, and there's nothing in the PERL that requires a written schedule so as to meet the requirements of Section 571. Thank you so much.
Thank you. So at this time, I will entertain questions from board members. Mr. Costigan.
I guess I'll go first. I didn't mean to do that first. I just want to, you guys need a sidebar?
I'm sorry?
You need a sidebar?
Oh, no, sorry,
Okay.
sir.
Just on the question of the classification, are you saying they are in the class of battalion chief, or are they a subset of the class of battalion chief?
That's what we wrangled about for about 3 hours with the ALJ following the evidentiary hearing. I guess for practical purposes, you would say it was a subset. You would have the bargaining unit up here, which is
No, I understand the
everybody,
classification.
and then the battalion chief, and then the pay differentials being a subsets down below. So
I just want to be clear. You're not saying that they're in any other class than that of a battalion chief?
not for their rank, no.
Okay, because in your letter brief, you tend to make the argument that they're a special class, and as you know, the only folks that can create classifications are the State Personnel Board.
Oh, correct,
So I
sir.
just want to make sure that we are clear
Yes.
on the classification designation as a battalion chief.
Yes, no, that is correct, sir. And what we were trying to clarify with the ALJ and with the board, that class of employment, which, yes, of course, that a class cannot be created as far as an employment classification, is different from a class of employment under 20636E1.
Because you're relating to pay, and I just can't lay my hands on the letter right now, but just again in the cover letter, sorry, I didn't think you were going to call me first. My apologies. Let me
That's all
pull
right.
this back up. Letter. Consent item. Because I think it was on page 2 of your letter, second paragraph. I just want to make sure that we're just on the same page. Let me see if I can pull it up real quick. If you want to come back,
Would you like me
Madam
to come
President,
back to
just
you,
come back to me,
Mr.
please.
Costigan?
Yes,
Okay,
thank you.
we'll do that. Ms. Brown.
Thank you. My question's for Mr. Shipley. I heard opposing counsel state that in accordance with the MOU 10.1.6, there was a mandatory payout of holiday pay, but for the rest of the members, they could take up to 4 days cash out of holiday pay. And my question is, were those 4 days pensionable for other people in that class?
They would have been pensionable if they had been allowed, but even though the MOU says that they could possibly receive that pay, CAL FIRE never actually allowed anybody to cash out the holiday pay. So even though it's put in the MOU, and I think it basically says if the budget allows or if the unit allows, it was never allowed. So no other firefighter of CAL FIRE actually ever received any cash outs, even though their MOU says it's a possibility.
And we're certain of that fact. Nobody else ever received the 4-day.
The testimony from Mr. Hale and Mr. Wolf was that during their tenure, they were not aware of anybody else in CAL FIRE ever being able to do that.
Thank you.
Thank you. Ms. Taylor.
Thank you. This is for opposing counsel. I just had a quick question on the MOU and the mandatory cash out. Do you have any idea when that was put into the MOU?
It was about 20 years ago, 1999 was when it first came in.
Okay. So I assume that CAL FIRE has had other union officers all the way back.
Going back to 1999, I believe there was one set of predecessors to Mr. Wolf and Mr. Hale.
Just one set?
I believe so.
Okay, and they did not ask for this as special compensation?
That is correct.
Okay, thank you.
There was, well, it would be outside. The record showed that there was a period of time where for Mr. Wolf, it was not being cashed out. Either it was forgotten or misplaced, or there was some sort of a bureaucratic issue, and then everybody got on track, and it's been cashed out ever since that time. So What happened before Mr. Wolf and Mr. Hale may have.
So you're saying you're not sure if they even got the cash out?
We're not sure.
Okay, thank you.
Thank you. Mr. Slayton.
Thank you, Madam President. I want to ask Respondents' Counsel about this on-call versus required to work during a holiday. So I spent 30 years in my career essentially being on call all the time and worked sometimes on holidays, but it was at my option to do it. Where in the documentation is there the requirement for these two men to answer the phone?
And sir, there is nothing in the documentation. Otherwise, I feel like we probably would not be here if we had documentation. There's nothing in the bylaws or the Constitution of Local 2881. There is no employee handbook that sets the schedule for the president and the state rank and file director. There could be any number of reasons for this, perhaps because there has not needed to be. There has not been an issue of the president and state rank and file director being unavailable when necessity has
Well, certainly
demanded it.
Certainly it's clear that they took their jobs very seriously and felt an obligation to be responsive. But I want to just understand, if these gentlemen over 10 years, 8 and 10 years respectively, spent time, had a Thanksgiving meal with their family, and their phone rang, that the option of taking that call, that was an option for them to do that. They were not mandated to take that call.
And Mr. Hale, at the remand hearing, Mr. Hale, Mr. Lopez, and Mr. Edwards testified that based on their observations coming up through the ranks in the union and their conversations with their predecessors, that they did not have the option to disregard the call, put it on hold, respond later, that it was required that when the phone rang, and that is during the weekdays, non-holidays as well, that their job was not to come sit at a desk and write a brief like mine is, but to more answer the phone and respond to the needs of the members and the state as those needs occur, and those needs are constant.
Okay, so if they had not taken the call, let's take a sample situation where they just didn't take the call, let it go to voicemail. What were the ramifications? Who would be in charge of admonishing them or saying you didn't do what you signed up to do? What would be the ramifications of not taking the call?
Mr. Hale testified that he believed he would have been fired if he did not take the call. Now, that would have obviously only been able to come, as far as his employment, to come from the state. The executive board of Local 2881 would be the authority to remove him from office.
I see. And it wouldn't require an election to remove him. I see.
No.
Okay. All right. I may have more questions later, but thank you.
Thank you. Ms. Hollinger.
Thank you. Couple of questions, and I think for CalPERS counsel. My question to you is this. So they're being ranked as battalion chiefs. So then how are they able to carve out a class of 2?
Well, I would argue that they would not be able to.
Right.
That they can't carve out a class of 2, and I think part of and what I think Mr.
But I'm trying to find, I'm not hearing the rationale of how you're doing that, because my concern is you would be creating a very dangerous precedent of going forward. So
And I think that's CalPERS, and that's what led to CalPERS' determination that you have to look at the most logical grouping, and the most logical grouping would be that they would be with other firefighters of similar rank.
Right, but you stated that they're battalion chiefs, so now you want to create a subset?
Well,
I mean, where is it written?
Well, the employment classification is battalion chief. Their rank or employment classification is battalion chief. But then there are, and we have used the term, I guess, subsets or different groups or classes that receive pay differentials within that rank. And for example, there's hazmat personnel in the MOU. That's a limited number of hazmat personnel. I'm not sure the number, but they receive a pay differential for being in that hazmat position. that is independent of their rank. They could be an engineer or a captain or a battalion chief, but if they hold one of those limited positions, they get that pensionable pay differential.
And Mr. Shapley, my question to you is, to be pensionable as comp, is there ever a situation where someone is pensionable at comp when they did not pay the contribution?
I think there would be a requirement that they would have to pay the contributions, that the employer and the member would have to pay contributions.
And that wasn't done here, correct?
That's correct.
Okay, thank you.
Thank you, Ms. Hollinger. Mr. Jones.
Yeah, thank you, Madam President. Yeah, my question, similar to Mrs. Hollinger, Mr. Shipley, you made the statement in your opening comments that the data was never reported to CalPERS that would be considered pensionable. So my question to the opposing counsel is why not?
We don't know the answer to that either. Either it was an oversight based on, as I explained to Ms. Taylor, that whether it was actually paid out in the early years for Mr. Hale and Mr. Wolf's predecessors, or we're not sure why it was not reported as pensionable from the beginning, but certainly the respondents would acknowledge and be expecting that contributions would need to be made for this to be pensionable, including retroactively.
And how many years that this data was not reported?
It would be 8 for Mr. Wolf, I believe, and 10 for Mr. Hale.
Okay, thank you.
Thank you. Oh, Mr. Costigan, we're back to you.
Okay, now I'm ready. So first, before I get into my questions, I want to thank you all behind you for all that you do. I appreciate what CAL FIRE has done. I think you know the work we've done at SPB. Recently, we had the classification and testing issues. So my questions are not directed to you as individuals. I mean, I know we lost another firefighter last night, so I truly appreciate all of the hard work that you do. And I think, as we saw, particularly at our SPB, we take the issues related to CAL FIRE extremely seriously. So again, I just want to make sure that you understand these are technical questions, and the reason we're here is that reasonable minds are clearly disagreeing on the interpretation of a statute or the lack of a regulation or a statute. So I just want to set that. The concern I have really is I think we're interchanging words here, classifications and classes. Okay, they're two separate things here. I just want to first agree, only the State Personnel Board can create classifications. There's no disagreement they are battalion chiefs for purposes of the classification.
Yes, sir.
Okay. And there is no subset as it relates to a battalion chief. What we have are differentials in pay. And I understand hazmat, educational, smoke jumper, or whatever it may be. And then we do that across all classes on it. The disagreement here is not, and I know, and it was just back to your language, and it's just wordsmithing, I mean, is that they can form their own group or class of employment pursuant to the government code. We're not saying, you're not saying that they're forming their own class of employment as it relates to a state classification. You're saying by practice of what they did, they are entitled to a different set of compensation that is not necessarily spelled out in the MOU, the regulation, or statute.
Correct. I guess it is spelled out in the MOU, but right, we are not trying to adjust or maneuver the state classifications in any way, shape, or form. It's essentially, we're saying that this is a pay differential like all of the other pay differentials. And
it's the assertion that the MOU calls that out. And by the fact that they had bought down time, that they had bought down holiday pay, sets, even though the hazmat is specifically called out, and education and longevity, and I understand on the officer's case, because again, the goal is to have someone there in the community for a number of period of times. I mean, so again, I want to set the stage that this is not disparaging the work that's being done. This is just, I sort of hate black letter law sometimes because this is just a statutory regulatory interpretation. So the argument is, even though it is silent by the fact that you had two people, the argument is that created a subset for purposes of pay, not classifications, but by their actions, that they're entitled to, even though it may not be specifically called out the way that a hazmat is.
Correct, sir. Just as anyone could meet the qualifications of a hazmat personnel and earn that pay differential if it acquired one of those specific hazmat positions, anyone in the union can run for and be elected into one of the two union officer positions and then receive that pay differential being cashed out for their holiday pay.
I would say regardless of the outcome of this case, that clearly going future negotiations, this is something because of the way the workload has changed, the more clarification that you can get, the better off we are. And I certainly hope that regardless of the outcome of this case, that it provides some guidance as to next steps. So thank you, Madam President.
Thank you, Mr. Costigan. Mr. Fechner.
Thank you, Madam President. My concern is, first of all, to echo what Mr. Costigan said, I have the utmost respect for all first responders. My house was in the evacuation zone last year, and I was out for 9 days, and I watched what they did daily and was amazed with the work that was done. My concern, however, is when we talk about the word comes up of spiking, et cetera. Unless I misunderstood, I believe you said that these two individuals had no supervisors, they were not evaluated, et cetera. So if it wasn't written in the MOU, they pretty much made up their own rules. In most areas where two people work side by side, they would make an agreement. I'm going to take vacation now, you cover. I'm going to take this holiday, you cover. So if there's no written language in the MOU, they could have done that. Instead, they chose to make their own rules and not do that. Is there a reason why I should not understand this correctly?
Well, as was in the record, it was not so much making their own rules, and I guess they could have done so, but they operated from the past practice, from their predecessors, and from discussions with the expectations of the board, the expectations that were set out in the past, and with each other, that yes, they potentially, well, in theory they could have done so, but for all practicality, they couldn't. That the demands of the job were just too high as far as making sure everything got done when it needed to be done and all the concerns of both the state and the members were addressed. And this is a tremendously gray area as far as the documentation and the things that are easy to point to, but it was undisputed throughout the hearing and found consistently twice by the administrative law judge that the union officers worked all holidays. And so then the issue that we felt was, were they required to work all of the holidays? And we believe it's clear that they were because of the demands of the job.
Thank you.
Thank you, Mr. Fechner. Ms. Taylor.
Thank you, Madam President. I think I have a couple of questions for both councils. Ms. Cockrell, you had said that the MOU, it was in 1999 when the MOU was changed to that, and that they also don't get longevity pay when they're out, or do they?
They do, yes.
They do.
If they qualify for the pay differential, they can receive it. But as Mr. Hale testified, even if he speaks fluent Spanish, he's not in a position
bilingual,
that's considered bilingual. So he has to achieve the position in order to receive the differential for everything except longevity and education, I believe it was.
Everything except, okay. Okay, so that's where I was a little confused. And then the MOU says it's a mandatory cash out, and I think you had stated that no one else gets the mandatory cash out, and that CAL FIRE doesn't actually, while Mr. Shipley had said CAL FIRE allows 4 days in the MOU, they don't actually themselves allow it. They haven't, as far as we know, they have not paid that.
That is correct.
Okay. So, Mr. Shipley, I think I had a concern that might echo Ms. Hollinger's concern. Is this, not classification, so it's a confusing verbiage to use, but this, if we determine for the respondents, for example, if we were to determine for the respondents and they are able to have this as pensionable compensation, what does that mean going forward for the firefighters? That's where my concern is. What door are we opening for that compensation? And then can CAL FIRE employees start working through the MOU or however to get that as additional compensation, pensionable compensation?
I think the decision of the board today would impact the respondents, and it would impact other CAL FIRE employees who were in union officer on leave roles. I believe so. I think it's, throughout the record that you have in front of you, which is rather voluminous. The other firefighters, and that's what I was trying to address in my remarks, the other firefighters who are required to work on holidays, who are required to staff their positions regardless, without regard of holidays, if they actually receive the holiday pay, that would be pensionable because it would actually meet the definition.
Because it would be all of them in the class.
And if it was available to everybody. Now, if it's only available to a couple of the firefighters, then it wouldn't meet the definition. But if it was truly available to all of the firefighters, then it would meet the definition of holiday pay because they actually are required to work on holidays and they're actually in positions that require staffing.
And therefore, it's pensionable.
Correct. It meets the definition found in Regulation 571.
Okay, so you're saying that if, depending on the determination here, it only impacts the union officers, as far as you're concerned?
I believe so.
So anybody who was elected into the union positions?
Correct.
So and I too want to say that these are just questions. I'm a union officer myself, so I appreciate everything that CAL FIRE does. I want to make sure that we are addressing all of the technical issues here. So that was where one of my concerns lie.
And that's where it was brought up that it is in the MOU that it is something that's allowed. And so if it was allowed and it actually was paid out to everybody and everybody had it available, then it would be something that would meet the definition. The problem with, at least in my opinion, with the appeal is that nobody else ever got it. It was never allowed for the people who actually met the definition. But then you also have to go back to, did they meet the definition of holiday pay? Were they in positions that required staffing? Were they required to work without regard to holiday? And I would submit, even if you find that there's a group or class of two, they don't meet that definition.
So you're saying that they didn't have to work the holidays, is your opinion?
That's my opinion. My opinion was they were required to probably, I don't even think they were required. There was no mandate that they accept a call. They chose to do so. It was admirable that they did it. They obviously took their job seriously. I've previously worked at CAL FIRE, and I saw how seriously they took their jobs. But that's different than being mandated to work on holidays.
Okay. Ms. Cockrell, in answer to that, they made a choice, is what I'm hearing. And as a union officer, that I also am a little concerned about that, because I can take vacation time. I get paid by the state of California also, but there is requirements of work. So what, how is it that they were, you had said earlier, how is it that they were held accountable if they did not take those calls?
Well, I think the easiest way to see something on paper is that they were still required to report their time to the state, and that was undisputed in the testimony, that they would turn in their time cards each pay period. And for 8 and 10 years, not one time did they report a holiday. Now, someone was reviewing their time cards in Sacramento headquarters of CAL FIRE. There was testimony to that effect, and not one time were they ever challenged for not taking a holiday. And certainly somebody processing and seeing that these payments are being made year after year for the cash out, we would presume they would say, well, wait a second, you can take holidays. Why are you not taking holidays? They never did. They accepted that these union officers were required to work every holiday year after year because CAL FIRE management expected them to be on duty when CAL FIRE needed them. The governor's office expected them to be on duty. And so for 8 and 10 years, CAL FIRE never said, wait a second, you haven't taken a holiday. Don't forget, you need to take holidays. You have the option of taking holidays. They cashed out the entirety of the holidays each year.
Okay. So, however, you had stated earlier that they have, if they weren't available, that there was a way to remove them from office, and that is in their policy and procedures, their bylaws for the union?
The CNOP, the operating procedure, there is a procedure for removing the union officers in
without a vote. So once it's once they're elected, it's not there is a way to remove an egregious union officer.
Correct. There are multiple ways to remove, and the most expedient one would be through the executive board.
Okay. Okay.
And they're still state employees, so CAL FIRE could terminate them as state employees.
That we're talking about whether or not they're doing their union duties at this point, and their union duties, according to you, are being required to work holidays and all 365 days a year.
Correct, and theoretically, although this is probably an exaggeration, the state could find that if they're not doing their union duties, they are committing fraud or accepting state money under false pretenses, and terminate them on those grounds. So it's not documented in a clear way that would make it easier for all of us, but based on the practice, we believe it's clear that they were required.
Well, I will agree with Mr. Costigan. I think going forward, that might be something you might want to work on.
May I add one thing to that?
Yes, Mr. Shipley.
The argument is that the evidence says they worked every holiday, and it's just not true. The question was asked, is it fair to say, though, that you didn't receive calls every holiday? And the answer was yes. It was asked, would it be fair to say that you kind of worked on half the weekends? And the answer was yes. So there's no evidence that they worked every single holiday. The evidence is they said they didn't work every holiday.
Okay, thank you. Mr. Miller.
I have a couple questions. I guess I'll start with Mr. Shipley, and then also want to hear from Respondents' Counsel. So you mentioned that we were talking about classification versus a class. So here we're talking about a class potentially of 2, but it sounds like it actually could be a class of anyone who is a CAL FIRE union officer in a similar circumstance. So there could be more people affected now, retro, future, if you were to consider that a class of people that this decision could impact?
If I'm understanding the question, I think that it would, if these 2 individuals were deemed a class of 2, then that would probably impact the prior union officers who were in the same position as well as the current.
I guess that's sort of my question. Would it just be deeming these 2 a class, or would it be deeming people who were in a similar situation, which could be these 2 or these 2 plus some other number of people?
Well, I think you would have to look at the specific facts. The MOU indicates that these are the only 2 officers who are on full-time leave. So I think if you're looking at similarly situated, it really is probably just these 2.
So for now, we're talking about these 2, but it could have implications for others on a case-by-case basis?
I believe so.
Okay. My second question, it's kind of a mishmash. There's so many moving parts here. I just want to make sure I understand that for these officers, the leave cash-outs were mandatory. So they were mandatory leave cash-outs, and CAL FIRE did not report them as a PERSable income. They did not deduct contribution. For other firefighters, those were, in theory, possible or available, but CAL FIRE did not choose to cash them out. It wasn't at the firefighter's discretion. It was at the employer's discretion. Correct on that?
I think it actually probably was CAL FIRE had to allow it, and then it would be at the discretion of the firefighter as to whether they chose to cash the holidays out.
Okay. And so if CAL FIRE had allowed that and firefighters had elected to cash out some of that, then CAL FIRE would have reported it to CalPERS as PERSable income, and they would have then settled up or deducted their contribution if that had been the case.
That's correct.
And so if it weren't for this required cash out, that would have been how things would have worked for these 2 union officers as well, except for those provisions preventing that.
I would say except for the definition of holiday pay, which they did not meet. But yes, if they had met those definitions, it would have been, CAL FIRE would have paid the contributions, and the members would have had those contributions also deducted from the pay.
Yeah, thank you. And counsel, that's your understanding as well?
That is correct, sir.
Great, thank you.
Thank you. Mr. Slayton.
So let me build on Mr. Miller's question first. So there's an employee deduction that happens with a contribution. Is that correct? Pensionable?
Correct. Every member has to
Okay.
pay a percentage of the member
All right,
contribution.
so for 8 and 10 years, these two men did not see that deduction happening from their pay.
That is correct.
Okay. So I don't know to what level of detail people who work for the state follow these things, but I know I look at deductions and check and see if the deductions are proper. So does counsel for the respondents have an answer as to why this was not raised for this period of time? And they didn't check and see, well, gee, if this is pensionable, there should be deductions happening.
I don't have an answer for that, Mr. Slayton. It was raised upon Mr. Hale's retirement was what triggered.
Could you speak into the microphone, please?
I apologize.
Thank you.
It was the calculation of his benefits, his retirement benefits that triggered.
So only at the benefit time, not at the deduction time?
Yes.
Which went for a period of 8 and 10 years respectively.
And we agreed with CalPERS counsel in the beginning that we would not look at the calculations at this juncture, that if it was determined to be pensionable, obviously the respondents don't believe that they can just receive benefits without making the contributions. Right. So, yes.
Okay. So then I want to ask you about because it seems to be a lot of this case rests on the group or class issue, to make them a separate group or class. So in your statement, in your letter, it says the union officers may be a group or class of 2, not must be. So you're saying it's permissive, but where is the documentation in all of this time period, the 8 and 10 years that went by in an MOU, where is the document that says this is a class of 2?
There is no such documentation. I don't know. Similarly, in my research, I could not find documentation in other categories that says you, state employee, are in this group or class for the purposes of the pension law, section 20636E1. So I don't know if it's not verbalized or specified for anybody, or if it was this situation. I'm sorry, I simply don't have an answer for that.
So there was no documentation that this was a separate class. There's no documentation that any contributions were taken out for it, neither from the employer nor the employee. The definition of class, as you refer to Government Code 20636, is that, am I reading correctly? Because they share similarities in job duties. So describe to me the similarity or the differences between a president and a rank and file director. What's the difference in the job duties between the two?
The difference in the job duties is that the rank and file director deals with the more, I don't know, tangible perhaps is the word, the grievances, the negotiating the MOU, the more detailed elements that the president then handles the big picture of. The president deals directly with the governor's office, directly with the management on the bigger union in the state employment issue, whereas the state rank and file director is going to be handling to the state personnel board disciplinary appeals, grievances to CAL FIRE for the express MOU violations, whereas the president is going to be saying, well, we need to, probably in this scenario, fix the documentation for the cash out for the purposes of the PEARL. So it's sort of a big picture details
So one's
distinction.
a big picture union issues, and the other one is individual cases. Individual firefighters is the focus.
That's probably a fair discussion.
So why do you consider those are similarities in job duties then?
Because they are similar to each other as distinct from everybody else. The similarities are that they are running the union, that they are in charge of how the union operates, both as a whole and as individual members. And there are no other positions in the union, in CAL FIRE, or we believe in state employment, although we don't know that for sure, that are similar to these two positions.
Okay. And for CalPERS counsel, you talked about, Mr. Miller raised the issue about whether this applies to others as well. I can see the focus, obviously, in this case, is on CAL FIRE. But we have other unions, not only unions with the state, we have unions that represent workers in local government all over the state of California. So is it fair to say that the ramifications of this particular case go beyond the issue of union representation for CAL FIRE?
I think it would always be a fact-specific kind of inquiry, but I could see where determining how the board makes its determination on the group or class of employment issue, that it could impact other union officers who are on leave to perform union duties.
Mm-hmm. Well, certainly if I were in charge of negotiating an MOU, I'd be paying attention to this particular case, regardless of whether it was CAL FIRE or someone else.
Correct.
Thank you very much. Thank you.
Thank you. Mr. Rubalcaba.
Thank you. I have two general questions here. Yeah, I think most of them have been articulated, but I just want to get a clarification. Both of you have testified, or at least one of you have testified, that there's a law. The MOU provision has been there for some quite time. Does any council know the history of that? Why was that put in there, that there has to be a mandatory annual cash out?
It was to reduce the leave balances for union officers returning to the ranger units following their tenure. Now, that actually has not been put into practice since the cash out provision was implemented. The officers have retired rather than returning to ranger units, but they are not required to do so. So it would be a burden on the state for an officer to come back to a unit with, say, 10 years of vacation time, which they would then burden the unit with as active firefighters.
The other question is, when these people, they were in bargaining at 8, and through their MOU, they were able to take leave to do their union duties. Their class specification and their salary never changed. Is that correct?
That is correct. Well, it did not change on account of the union duties. The evidence showed that Mr. Hale and Mr. Wolf were actually both promoted shortly after they went into office.
Okay. Like Ms. Taylor, I'm not a union officer, but I am familiar with unions and I understand, and at least in my particular situation, there's when our civil service rules permit a leave, but there's always a separate agreement as terms and conditions. So I believe that whatever the reason was, there was an intent behind that MOU provision saying you have to mandatory cash out, and that has weight. That's the governing rule until it's changed. Some people have already stated that it has an impact and it perhaps should be changed. State law under compensation, I forget the citation, talks about special compensation on certain things, whether responsible for a guard dog or a bonus for waxing the floor. Some have been determined to be pensionable, others have not, like bilingual bonus for special skills. So all those can be, what's pensionable has been determined by law and CalPERS. And I know because I come from 37 counties, and we always look to CalPERS for guidance. And so sometimes things have to be determined. I mean, you have to assume that a law was put there for a reason until it's changed. So I think what's governing here is there's a class specification. So I don't think the argument about whether it's a subject or it's a class spec. And there was a reason for that MOU provision. So the terms pension spiking came up a couple times, and I know that's something that's weighs heavy on this case, whether it is or isn't. on a personal level, one may think, maybe they didn't work the holiday, but there's nothing in the agreement between the parties that said you did or didn't. The agreement was your class, you're still your same classification, your same provisions apply. So I think it's a question of what was the intent of the parties and whether somebody that's what I'll say. Anyway, I'm just talking. I think I asked my questions. Thank you.
Thank you, Mr. Rubalcaba. Are there any further questions from the board at this time? Seeing none, I would entertain a motion to recess into closed session for deliberation. Moved by Ms. Taylor, seconded by Mr. Costigan. Any discussion on the motion? Seeing none, all those in favor say aye. Aye. Any opposed? Motion passes. We will now recess into closed session, and we will reconvene after our deliberations.
Thank you for your time. We appreciate it.